Welcome back. Still waiting for opening statements to begin in Florida versus Robinson. Let's go into the courtroom. The defense has an interesting point they want to put on the record, that the jury has been allowed to choose face mask or shield. You do whatever comfortable. The defense would rather that the jurors wear a shield so they can see their reaction.
I instructed the witness to really listen.
Did she go get the jurors? Okay.
All right, as we wait for the jury to enter the courtroom to hear opening statements for both sides, prosecution, of course, will go first. Kristen Nyquist will be delivering the opening for the state, and Maria Dunker for the defense. Kelly Hyman is with us out of New York, trial attorney. Kelly, what are you looking for here? Opening statements, if you're the prosecution, they have to set the table, don't they, for expectations. There's no physical evidence here in this case. This is all witness testimony.
No, absolutely. Good morning. Thank you so much for having me on the show today. It's great to be here. Absolutely. As you stated, the state has the burden, so I think that they're going to lay out their case. And so they're going to talk about the witness and what they're going to say and how they're going to testify. And so that way they can lay a foundation. I think defense is basically going to say you have to hear all the evidence, the state has to prove their case, and then also they assert a self-defense. So it'll be interesting also to see whether the defendant does take the stand for, the self-defense claim, but I do believe that he will take the stand.
How else would they get that across to the jury? Just through cross-examination?
Right, yeah, that's true. But, people always want to hear someone's story. And I think that's really compelling, especially if you're asserting that it was actually self-defense. But, you have to be, very careful. Ultimately, it'll be up to the defendant to decide whether he's going to take the stand and testify or not. But I believe, most jurors sit there and want to hear the story. They want to know why something happened, why someone did something, what was their motive, what, happened, and they want to hear the story.
As we watch the defendant walking into court today, this morning, he's been out on bail for the past 6 years after this incident took place. And during that period of time, he turned down a deal from the state for 15 years. 15 years, likely, with good behavior, served 11, 12. He said, no, I want to roll the dice. I am going to fight this tooth and nail. Good decision or bad decision? If you were representing him, Kelly, would you have kicked him and said, you better take this? Because you're facing now, you're exposed to life.
Right. Well, I don't know all the evidence that the defendants have, up their sleeve, so to speak. And so ultimately it's the client's decision. But if he, is self-defense and, that's what he truly believes and that he didn't, and there was no intent there, then, sometimes you have to go for it. But, ultimately it's going to be up to the jury. And so sometimes, it's risky. You never know what the jury is going to make a determination. They might say, yes, he's, not guilty, self-defense, or no, he's going to spend the rest of his life in jail.
One of the things we'll listen for here in the openings is from the prosecution and the defense, clarity on the law, because he's facing felony murder, and the attached felony is burglary. And it doesn't, to the average person, well, he didn't go there to steal anything. He went there to fight. That will be crucial, will it not, to make it clear?
Absolutely, definitely. And what was his intent? Exactly, as you said, Ted, you bring up a really good point. What was his intent? What exactly was he, going to steal? Did he break into the place? What exactly, transpired? But I also think it's very interesting about the witness tampering, how he basically, when she takes the stand, of what exactly he said to her and what she thought about that. And, that's really compelling. And ultimately the jury is going to, hear all that and hear all the witnesses. But for the prosecution, the witnesses are key. They are their key to the story and key to the case.
Absolutely. Let's go in. Jury is seated.
help you maintain social distance during the course of this trial. So if there's anything I can do to help you or accommodate you during the trial, please let me know. I know it's made it not as comfortable, perhaps, as the way we did it before when you're all in there, but we do have seat cushions for those of you relegated to the non-comfy area. And as I said, it's up to you as a juror if you'd like to switch around your seats. Just because you're in numerical order right now does not mean you have to stay that way after lunch when you come back. So if y'all decide to swap out comfortable seats during the course of the trial for everyone else, that's fine with me.
I'd like to give one of the ladies this seat here, and I'll take the hard bench.
Oh, wow. A gentleman already. Any ladies want to take him up? Any back problem issues? Oh, look, you've guilted all the other men into doing it too. All right. That's very kind of you. I appreciate that.
I'll do the same.
Everybody's good? Wow, you set the bar high now. Look at everyone you've shamed. Everyone, right? All right, too funny. Good morning. Have any of you seen or heard or learned anything about this case or the people and places involved in this case or anything at all related to jury service and what's going on in here since we were last together, or quite frankly, at any time, either inadvertently or otherwise? Vigorous head no's from absolutely everyone. Great, thank you. As I warned you, I do have some preliminary instructions to read you that I'm required by law to read you before we get started with the trial today. So please pay careful attention to me as I do that. You have been selected and sworn, as you know, as the jury to try the case of the state of Florida versus Aaron Robinson. And this is a criminal case, as we discussed, and Mr. Robinson is charged in 3 counts with murder in the first degree, burglary in the first degree, and in tampering with a witness. The elements or the definition of those crimes will be explained to you later.
Okay, while Judge Ward instructs, we'll take a quick break, get you back in time for the opening. Stay with us.